Thank you. My name is Lisa Iwan, and I was going to start out my talk by saying I've been coming up here for 40 years to the Senate Judiciary and House Judiciary Committee, and I was so impressed with how Aaron runs such a tight ship and a great hearing, and how so many people stayed, and now all of a sudden everybody left. I don't know what happened.
Well,
I hope it wasn't me.
No, not at all. Let me just share with you that everybody that leaves the room is probably taking either a nature break or they're eating, but when they're eating, they're watching. So
okay, I get it. Well, thank you very much.
You're welcome.
But it really has been a wonderful evening. I have to say I'm very impressed with how attentive you've all been, the good questions that you ask, and how the chair runs such a tight meeting. I really like it. And I'm going to stick to my 3 minutes as best I can. I've submitted 4 pages, single-spaced, of testimony, and I won't address the issues raised in there because I wrote it in a very a very practical way. I've been in the trenches practicing law in the state of Rhode Island for over 36 years, and I've done over thousands of adoptions. And I went to see the chief judge of the family court, with whom I believe I have a good relationship, to talk to him about this bill, because I've been on a committee of people, a bunch of brilliant people. I referred to them in my the testimony, the written testimony. We've been working on this bill for over a year, and I presented it to him and met with him to talk to him about it. And one thing he said, I was very shocked and dismayed to get these letters about a half an hour ago and to see that he was objecting to both of these bills. And the things that he says in the bills that he objects to, they're 2 things, and I want to point them out and distinguish them for your understanding. Because you are a different branch of government. You are the legislature. You are the policymakers of the state. The executive branch and the judiciary are 2 different, they have separate roles, and I want to point that out. Now, for over 50 years, anybody's been able, as Sharon Santilli has said, any person could walk into the Department of Vital Statistics and acknowledge paternity. Nobody asks them, are you married? Nobody asks for a DNA test. They sign an affidavit, it's notarized, and their name is put on the birth certificate. For probably over 100 years, what's happened in the state of Rhode Island and everywhere in the United States, I presume, when a baby is born, a nurse walks into the hospital room and looks at the people in the room and says, who are the parents? Are you the parents? Sign here. They don't ask, are you married? Will you submit to a DNA test? They acknowledge paternity, they acknowledge parentage, their signatures are witnessed, and their names are put on the birth certificate. This does not happen for same-sex couples. Now, these are the things that Chief Judge Fort, with all due respect, disagrees with. He feels like his judicial power is being usurped because he's not able to he feels like the legislature is giving a rubber stamp to adoptions. That is not the case. If you look at the affidavit that's in the Adoption Act, it's much more specific than the one that's in the Department of Vital Statistics. Basically, when children are conceived via artificial insemination, there are only 2 parents who plan to conceive, who plan to raise, and who will raise those children. And these 2 bills just clear the pathway to establish the parentage, a very sacred, fundamental right in this country. And as you know, parentage is a rebuttable presumption. And as Sharon said, and Polly also, children conceived during a marriage are deemed a child of that marriage. But we all know that's not true. Children are conceived through the neighbor, the mail carrier, the pizza delivery guy, They're not all children of that marriage. And the seminal case on, and I don't say that as a pun, the seminal case in the state of Rhode Island is Pet Novello versus Pet Novello, which is a heterosexual case, there are very many cases like Pet Novello where a person files for divorce and the other parent answers by saying, oh, by the way, I'm not the parent of that child. And the family court says, whoa, you can't just step away from your parental responsibilities because you're getting a divorce and say you're not the parent of the child when both parents have condoned and fostered and created a parent-child relationship. And so we also have the Romano versus DiSenso case, which is a lesbian couple where that happened when they separated, and the biological parent said, I don't want the non-bio parent to have any relationship with the child, and the family court said, but wait, you fostered and condoned and created a parent-child relationship. You can't just advocate that because you're separating. Now, you're going to hear lots of testimony, and you'll receive written and oral testimony about the trauma of the adoption hearings that gays and lesbians have to go through in the state of Rhode Island since Judge Bedrosian and since Judge Fort became the chief judges. But I want to point out that when Chief Judge Jeremiah sat on the bench for 24 years, I went to see him in 1986 when he became the chief judge, and I explained to him how unfair it was for gays and lesbians to have to go through this adoption process, which involves a 6-month waiting period, which is terrifying to the non-biological parent, 3 home studies, which is expensive and time-consuming, and invasive of privacy, letters of reference. They have to hire a lawyer and go through an adoption hearing. It's horrible, it's expensive, and time-consuming. I explained to him how unfair this was when there were only 2 people on the planet who intended to raise the child or children. He agreed with me, and for 24 years, we had adoptions with gays and lesbians, and literally I did hundreds of them, where we waived the home study and the 6-month waiting period. That happened for 24 years. And then when Judge Bedrosian became the chief and Judge Fort, everything changed, and we're now back to the days of home study, 6-month waiting period, and all of that. The sky did not fall. And I want to point out, Madam Chair, when you were out of the room, I wanted to thank you for how you run a tight ship. And this is one of the best Senate Judiciary meetings I've been to in 40 years, because you do stick to the 3 minutes, and I'm almost done with my 3 minutes. But I
was just going to cut you off, but you're complimenting me, so go ahead.
And I also will submit a letter to you to help answer to your screaming sister and other members of the family court bench.
You can call her yourself.
I will call her
thank you.
myself on my cell phone on the way home. But I want to point out that, again, that you are the policymakers of the state of Rhode Island. And should this policy be adopted by the state of Rhode Island? Yes. Should you be the brave warriors that instruct the other legislative branches what their role is, other branches of government what their role is? You are the policymakers. This is the policy that should be adopted by the state of Rhode Island, and I'd be happy to address any questions that you have.